everyone, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and welcome to Last Week Tonight, where we answer your questions and we talk about your comments. It's all about you, the viewer, on this episode. And today is October 17th, Tuesday. So we're gonna go into these questions. And here's a question from a user GG. And he says, I had a high-grade rotator cuff tear and a 95% bicep tear in the right shoulder, slap lesions tear, AC joint sprain with a post-traumatic AC joint arthrosis, plus a herniated disc in the neck and in the lower back. The driver of the other car was 100% at fault. I was a passenger, and he has unlimited insurance. What should I start my settle piece at? Yeah, so I mean, that's a serious case. I'm sorry to hear that happened. In terms of settlement, I would say it sounds like it would be a high six-figure, maybe even into the seven figures, into the millions if it's prepped the right way. So it sounds like a good case. Yeah, feel free to text me, 347-566-9595. I'm here for you. You know, whether you need a lawyer or not, you could text me. I'll try to find the time to give you some kind of text response, some kind of, information. It's important to know where it is, what stage it's at, and a few other questions. But, I try to be a resource. I try to be a guide or a counselor and help. I want to help as much as I can. Okay, let's see what other questions. The Machine in Incorporated says, let's talk ASAP. Yeah, absolutely. Just text me to that same number, 347-566-9595. And then Rinder Show says, question, sir. So I've heard some things about how this works. If someone trips and falls in a workplace due to faulty floor mats, and he's been complaining about these mats for months and nothing was done about it, how does one sue the employer if you accept workers' compensation? It prevents you from the ability to sue. According to Florida law, it says that once the person is on workers' comp, it automatically prohibits the employee from suing the employer. So who exactly is the employee suing? Yeah, that's a good question. So we handle work accidents, right? Work injuries, but you can't sue as the employee, as the injured employee. You can't sue your employer. So who do you sue? You sue any third party that may be at fault. So for example, if somebody slips and falls on a faulty floor mat, now if you work for a certain company, you might work for like a McDonald's, let's say, and then McDonald's puts that floor mat there, but maybe the floor mat comes from a company that delivers those floor mats, that services those floor mats. You could sue that company. In the same way, if somebody falls due to a puddle, you can't sue maybe the McDonald's, right? Because you work there, that's your employer, but you could sue a cleaning company. Let's say if a cleaning company goes in, if it's not a McDonald's probably has their own cleaners, but if it's like an office building, you might have ABC Cleaning comes and cleans the office building. If the guy from ABC Cleaning is mopping and leaves a puddle, you slip and fall on that, you could sue ABC Cleaning because you're not suing your employer. So I hope that helps. You can't sue your employer, but you can get workers' compensation benefits from your employer, and those are usually lost wages and medical bills. And sometimes you can get a settlement of the workers' comp as well. And I'll leave that to workers' comp lawyers. I don't really do the straight workers' comp, although I know a little bit about it and I interact with it as part of my personal injury practice, but I'll leave all the details, the nitty-gritty about workers' comp to the workers' comp guys. Okay. And then Jack Silver says, I can believe he is a trial attorney. Boring. Ooh, I don't know, Jack. I'm hurt. I'll try to spice it up for you. I gotta get more excited. I gotta get Jack back. What does Jack want to see? I mean, sometimes we got to get a little boring because we got to, be comprehensive and cover all the issues. And if we don't cover the issues, then, then it's not, it could be exciting, but if we're not complete, right? If we're not thorough, then we're just exciting, but then we're not really doing a good job for our client. So I guess sometimes it has to be a little boring, but stick it out, Jack, stick it out. Okay. And then Julia says, shame on you for promoting a sue culture. Oh my God, what's going on today? We got all these haters. Oh, back injuries. She's responding to this video, back injuries and your personal injury lawsuit. I guess it's a video from a while ago, maybe a few years ago, where I talk about back injuries like spinal fusions, epidural steroid injections, percutaneous discectomies. But she says, I'm promoting a sue culture. I don't think so. I mean, I'm not really promoting a culture of any kind. I'm just giving people information about back injuries, right? So people get into various incidents, a slip and fall, car crash, truck accident, whatever it may be. They get a back injury. They might be curious about different types of back injuries, types of treatments, and then if they have a case or if they're looking to maybe file a case, how much it's worth. But I'm not promoting to go out there and start suing for frivolous lawsuits. In fact, if she watched my channel, she would know I'm the exact opposite, right? Because what I'm saying is we have to look at the true cases, the cases where people have been truly hurt and have life-changing forever injuries, but they don't get justice. And why don't they get justice? Because the insurance companies put this spin on everything that there are a lot of frivolous lawsuits out there, everybody's a shyster, everybody's out there to make a quick buck. But what about the really true serious injury victims, and who's going to take care of them? So I feel like that's my job. And I feel like the insurance industry sometimes lies and convinces people that it's a sue culture and that that's the problem. But in reality, would you be open to the possibility that these billion-dollar insurance companies don't have your best interests at hand, but really what they care about is their own pocket? How about that? Okay, let's go to the next question. User KQ says, have you ever had a claim against the company that used Sedgwick as their TPA, and that's third-party administrator? If so, do they usually comply, or are they tough to do battle with? Or have you heard in regards to Sedgwick? Yeah, I mean, usually when I see Sedgwick, I'm kind of happy because Sedgwick usually is the TPA for large policies, like many, many millions of dollars. I think they might, in the past, they even administered like Coca-Cola and large companies. So whenever I see Sedgwick, it's usually a good thing. I don't think they're very hard to deal with. Usually you're not really dealing with them anyway, because you're going to be dealing with the carrier, or the carrier is going to hire a lawyer. If it's a significant case, then the TPA is going to hire a lawyer working with the insurance carrier, and you're going to deal with that law firm as well as the carrier. Sedgwick only probably has authority up to a certain level, so it's a truly big case that you're going to like blow right by Sedgwick. But yeah, that's usually a good sign. So that's a positive thing. And then Taco says, what advice should a client receive from his from his lawyer at the first consultation? Yeah, so I mean, the advice that they should receive, and he's looking for like do's and don'ts. Well, I guess like, I think the important thing for a client to receive is just like an overall welcome and find out about the lawyer. The lawyer should find out a little bit about the client. In terms of do's and don'ts, I mean, obviously do get medical treatment. That's the most important thing. If you don't get medical treatment, then nothing else really matters because they're injury cases. So if you're not getting medical care, then you won't be able to prove any type of injury. And so everything else, like from property damage to, these appointments, to phone calls, to, getting funding or whatever, all these other things, just like they don't matter anymore because the heart of the case is the medical treatment, right? That's what keeps the case beating because that's your medical care, especially like in car accidents, because you have to prove, like in New York, you have to prove a serious injury. So if you don't have medical care, there's no way you're going to prove a serious injury. So now the case is just worthless. Where slip and falls, maybe it's a little bit easier, but still you want to get your medical treatment. You always want to get your medical treatment. That's just the number one thing. Let me see what else he says. He says, I told him, good question. I'll do a video about that. Yeah, maybe I could do a video just about that. I have to like outline it, all the different things, the do's and don'ts, and what a lawyer should tell their client. But yeah, I did say most important to get medical care and do communicate with your lawyer. So he or she is your true counselor or guide and a trusting relationship is formed. Yeah, I think that's very important too, because you see a lot of the questions, even the questions here, a lot of the questions, people are asking me questions, but they're not asking their lawyer, and maybe because their lawyer is not answering their questions, but why not, So there should be that open line of communication. And then he says, should a client be warned against talking to anyone? Also the sending and receiving of messages such as email, mail, and texting. I mean, talking to anyone, I think it's fine to talk to I don't know like what they mean by talking to anyone. I mean, you definitely don't want to talk to anyone that might be like an investigator coming to your house, but I don't think that's really happening that often. If you're just talking with your friends, or, I mean, obviously social media, you want to be careful if you're saying that you're hurt. And if you are hurt, you don't want to be posting on social media anything that contradicts that. But yeah, I mean, you could talk to your friends, you could talk to your coworkers. I don't think, I wouldn't be like afraid, like, oh my God. I just, continue to live your life. As long as you have a true case, it's a legitimate case, it's a case of merit, you shouldn't be worried about anything. Okay, let's see what other questions we have. Lost in Awareness says, at a deposition, does the plaintiff's attorney already have all of the evidence that the defense attorney gained from the interrogatories? And I guess what he means by that is that the evidence that the defense attorney learned from the plaintiff's answers to interrogatories. So yeah, I would assume the plaintiff's attorney should have it, because usually the defense just asks for basic information like your medical records, authorizations to obtain medical records. And he was talking specifically about gym records. So I would think from the gym, yeah, I mean, I think the plaintiff's attorney should have it. I mean, a good plaintiff's attorney, if they're going to give the authorization to the defendant, that means the defendant can get these records. So you don't want to give an authorization or power for them to get records if you don't even know what the records are, right? Because then you're just giving them something, but you don't know what it is. It could be really bad for you. So if you're going to give them an authorization, then go ahead and send a letter to that gym or to the doctor and get the records yourselves. Now you have the same records that you just gave the defendant, your adversary. You just gave them the records, get it yourself. I mean, of course, that's just common sense. Anybody who doesn't do that would just be like foolish, I think. Okay. Then here's another person says, do you think this is a strong case? Fell down 20 flights of steps, cervical radiculopathy, medial meniscus surgery, slap surgery, that's to the shoulder, I believe, a slap tear surgery, and a bulging disc with nerve damage and disfigured fingers. And the negligence was steps were wet and unsafe. Yeah, I mean, that sounds like a great case. I don't know where it is. I'll put in here. Feel free to text me if you want a consultation. I don't like giving too much information over like YouTube because, I can't, first of all, I don't have a lot of information, so I can't, it's like what you put in is what you get out, right? So if you give me a little bit, like, hey, I have a slap tear, what's it worth? How could I really answer that? So the best way to do it if you really want a consultation is to just text me. We could set up a time to chat, because that's really, it goes into like all those factors that we talked about before in all our prior videos. Things like, how did it happen? What's the liability? Do you have an expert? Where is it pending? What stage is it in? Have they talked about your story? Do you have like a human story or a biography to explain how this has affected your life? Has this impacted your life, your family's life? All of these things. There's just like all these factors. It's kind of hard to assess a case or evaluate a case without all that. Okay, let's see, maybe do one or two more questions. Here's a question. Hello, Mr. Frekhtman. My case is in Manhattan. The opposing counsel, my lawyers recently told me they were going to ask the opposing counsel for $12 million, but in private, they told me that pre-jury settlement is somewhere between $4 and $5 million. My question to you is it smarter to settle or go to trial if the case is very, very strong and the other side has over $20 million in insurance? My lawyers told me that even if we got 10 or 15 million by the jury, that the opposing counsel could not only fight that award, but it could possibly take over a year after the award, and also a judge could rule on it and bring it down to the same 4 million after the award. Yeah, I mean, it's possible. I mean, it's hard to say. I would say that if it's a case like that and you have 20 million in insurance and it's a strong case, you might want to just take it to trial and get that verdict. Because if you get a big verdict, like 15 million, for example, 20 million, well, then they may not pay you the full 15. They might say, I'm going to file an appeal. But now you say, look, I have 15 million and it's supported. I have economic damages. I have pain and suffering. And look at my severe injury. I could obtain this money. Plus you have interest running, right? Once you get the judgment. So now they might offer you more. Instead of 4, they might say, okay, well, you hit us for 15. We could offer you 9. We could offer you 10. So I would fight them, but it's up to, I would leave it up to you and your lawyers, but I think you should probably not back down, because 15 or even like 20, if that's how much they have, and then 4, that's a big difference. Just like if a case is worth, let's say, $20,000, well, why should you take 4,000, right? It's the same thing. If a case is really worth 20 million, why should you only take 4? Okay, and then Just Suits says, question, do you have to go through court-ordered mediation, especially when you know the other side are not willing to even start at a reasonable amount? Example, if a case value in the past verdicts is around 1 million, but they are not willing to start even at 100,000, why do the mediation? Well, I mean, if it's court ordered, sometimes the lawyer has to show up because it's court ordered, but you could throw that back at them. You could say, look, I'm here in good faith. Here's my record. These cases go for $1 million. Here's other cases I've handled. Here's other cases other lawyers have handled. This type of injury justifies $1 million in this particular city, and here's the proof. Now, okay, let's talk Turkey. Offer me $1 million. Okay, you can't offer me $1 million. Okay, let's talk about 900, 850, but give me a reasonable offer. Wait, you can't even give me $100,000? Okay, judge, just set this down for a jury trial. You see, they're acting in bad faith. Flip it back on them and make them the bad guy. Why should they whittle you down and say like, oh, you should take like 50,000 or whatever they are willing to offer, if they're not even willing to offer you 100,000? Or ask your lawyer why. Why are they not willing to offer you even 100,000? Is it because there's some problem with your case that maybe you don't know about? Or is it just that they're just being cheap and trying to save their money? In which case it's bad faith and you can hit them for more than 100,000, So I would just, but the other thing is, like, when you're at a mediation, sometimes the lawyer, a demand doesn't have to be a monetary demand, or sometimes what's your demand? Well, my demand is a jury trial, and that's what you have to ask for. And that's just, because I don't think you should be, asking for a low amount if you have a case like that. So good luck to you. It sounds like you have a good case. Okay, let's do maybe one more question. Bruce Joseph says, keep up the good work. Absolutely, I will. Thank you. Dwayne Carter says, hello, can summary judgment be filed before discovery is complete? Yeah, absolutely. As long as there's evidence to support it, you could file summary judgment early. I mean, sometimes I've even filed summary judgment like right when I got the case. Like, for example, I just got the case, the accident just happened, but it was like a clear rear end. Like, my client has stopped at a red light. He's been stopped for like a minute, like 60 seconds. Somebody else is speeding drunk and just rear ends him. Well, why should I wait? I'm filing the lawsuit today. I can get an affidavit from my client. I can get photos of the vehicles. I can get, I could just file the summary judgment tomorrow. If I file the lawsuit today, the case is in court. I file the motion tomorrow. I get a judgment in a few weeks. And then now they have to pay interest, right, on the judgment. So why not get that judgment? Like, what's the downside? There's no downside. And even if I lose the motion, usually the judge will say, well, it's premature. I'm going to deny the motion, but you can file the motion later. So there's no downside. But if I didn't file the motion, the worst thing that could happen was I wouldn't have a judgment. And if I lose the motion, I don't have a judgment. So I'm exactly in the same position. You see what I'm saying? I'm not hurting the case by filing the motion, but I could potentially be helping the case. And I've gotten cases, summary judgments granted like that, like where an accident just happened, we file the lawsuit, like 2 days later, we file a motion for summary judgment, we get an affidavit from the client saying, I was stopped in my car, I was stopped at a red light, I was stopped for 60 seconds, all of a sudden I just heard a crash. And now the way the law works is you've established prima facie, you've established enough evidence for that summary judgment, right? Because there's a presumption that the vehicle that's in the back of you, in the rear, is going to stop and keep a safe distance between the front of its car and the back of the car in front of it, It has to keep that safe distance. Now, if it doesn't keep that safe distance, then it's at fault. So the presumption is, by you filing that summary judgment motion and by you explaining, hey, this is what happened. I was stopped at a red light, or I was slowing down in traffic, or I was stopped for the normal course of traffic, whatever the facts may be, and then I got hit in the rear, there's a presumption that they're now at fault because you've tendered evidence, right, to say that they rear-ended you. So now it's the duty flips, right? And the burden shifts to them. Now it's their duty, right? The ball's in their court. It's their duty to now tell you and explain a non-negligent explanation, meaning they used reasonable care, but they still rear-ended you. And what would be a non-negligent explanation? Maybe if you went in reverse and hit them, or maybe if you stopped short where they couldn't have time to brake. But if they're going to say that, but usually they don't have a non-negligent explanation because it didn't happen, right? They would just be making things up. They can't do that. They can't lie. So you win, and it's pretty easy. Okay, I hope this has been helpful. Let us know what questions you have. This has been Last Week Tonight. We only got to about 4 days before, we only made it to about 4 days. I have to run, but I'll do another one. We'll take more questions, and we'll do some lives as well. Okay, have a great day, everyone. Please like and subscribe to our channel. We are here for you, and all the best.